Hi, my name's Bruce Mack, your host today and co-founder of Platinum Group Trust. I'm really excited to have you here. You're going to learn a tremendous amount of information regarding our proprietary and copyrighted trust. I'm a licensed financial advisor, investor, both with Bitcoin and real estate. I've been involved in over $92 million worth of transactions in real estate, business consultant, speaker, and author. And so I'm not distracting you. I'm going to turn off this video so that we can get right into the meat and potatoes of what this is all about. Also, I encourage you, if you don't already have it, to grab a pen, paper, a couple of sheets of paper so you can take some notes. At the end of the webinar, you will have an opportunity to book a one-on-one complimentary consultation so we can get to know your specifics and see how it does or does not dovetail with one of our trusts. Likely it will. So who's this for? Well, if you're a Bitcoin or crypto investor or you want to grow your assets and not have capital gains, or if you have assets over $100,000 and you're concerned with privacy and who's not, well, then this is definitely for you. So today you're going to learn how to, first of all, eliminate capital gains taxes on all your Bitcoin, crypto, and other investments. You're going to learn how to defer taxes in perpetuity on all your passive income. You're going to learn how to ensure your assets to be kept totally private. And you're going to learn how ironclad asset protection works in congruence with our proprietary and copyrighted trust. The strategy that provides this and more is the Titanium Vault Asset Protection Trust. So let's start with, what's a trust? Well, it's a contract between the grantor, the trustee, and the beneficiaries. The fact is, if you don't have a plan in place, then the government will take control. It's your choice. Meaning that so many people don't have any trust. And because they don't, they're headed straight for probate, where the government's going to step in and a trustee is going to get appointed. And I've seen in certain cases where estates have lost over 50% of their value because it went to settling the estate and to the trustees, which is an awful situation. So one of the things that our trust is an opportunity to be able to completely circumnavigate falling into probate. And also, we're going to take care of ensuring your family legacy by naming who the beneficiaries are from the hereafter. Platinum Trust Group, Titanium Vault Asset Protection and Tax Reduction Trust is a number of different unique components. Some of them are the fact that we have a dynasty provision, non-grantor, irrevocable, discretionary, complex, spendthrift provision, and it is not self-settled. There's many more components. These are just several of the key components. I really like to focus on this chart because it shows what our trust is versus what other potential options that are out there for you to hold your assets. One of them is a C Corp or an S Corp, a holding company. Some people use these days, most people use either Nevada or Wyoming. Those are the two most common states. Land trust and or a living trust or will versus our trust. So let's just whip right down through the chart. First of all, we have the ability to, yes, eliminate capital gains taxes, defer on income tax, avoid lawsuits, avoid judgments, liens reaching your business and or you personally, avoid probate upon death, avoid gift tax, avoid estate tax, ensure the beneficiary's assets are transferred, ensure the fact that it is a multi-generational wealth accumulation tool, and there are no annual fees. So let's talk about tax mitigation first, then we'll circle back and we'll talk about asset protection. It works It's a titanium vault. No one has ever failed an audit that has one of our trusts or been successfully challenged or overturned. I pose to you that we are in a time of transition with the new administration. And many of you have seen several of the things that I'm going to tell you today, right here and right now. And some of you haven't, and some of these will be new for you. So we're hearing about a 43.4% capital gains tax, up from roughly 20%, a doubling. This is huge, and this affects every crypto and Bitcoin investor right in their back pocket. There may be an increase in personal income taxes to as much as 39.6%. That's what's on the table right now. There may be a lowering of the estate tax cap, which is currently 11.4, 11.7 in the last year, down to as low as $1 million. Estate taxes can be as much as 55%. That could be catastrophic for people who have any kind of an estate. And there may be no 1031s, which is a deferral on properties if you're not familiar with it, and or no mortgage interest deduction for those of you who own a home. That's on the table for potentially being eliminated and or significantly reduced as well. You can run, but you can't hide. Bitcoiners are concerned over what the IRS has in store for them, and duly so. This is an article, a clipping from last week. The US Treasury may require crypto transfers over $10,000 to be reported. That was from Janet Yellen, the Department Treasury. You think your Bitcoin is private and anonymous. Well, not necessarily. As you can see, these are headings: IRS nabs big win over Coinbase. Coinbase notifies customers that it will turn over court-ordered data. So if they want it, they're going to get it. It's just that simple. This is a article that was recent, going back a couple of years, in as much as the IRS started sending out letters to currency owners advising them that, hey, you're in the system. We're going to find out about you, and you need to file returns. And they went on to say in several other letters that people have received that if you don't file, that they're seeking criminal penalties. So you don't want to be a non-filer. That would be a horrible potential disaster for you. Many crypto investors, the IRS taxes the following Bitcoin and crypto incomes. We want to be very specific. If you fall into any of these categories or multiples of these categories, you will be taxed. Mining income, staking, lending, margin trading, and or Bitcoin for purchases, and or crypto for purchases. When you engage in any of these activities, unless you have one of our proprietary copyrighted trusts, you're going to get taxed. That's just the way it is. We have the ability to legally reduce taxes utilizing our one-of-a-kind registered copyrighted trust to defer taxes legally per the IRS Trust Tax Code. The trust defers and minimizes income and estate taxes to the fullest extent that the IRC, which stands for Internal Revenue Code, allows, in most cases, between 78 to 97%. Now, when we're talking about business income, so let's just say you have a car wash, or let's just say you are a business consultant, or whatever it is that you do for the business that you own, we're talking 78 to roughly 85%. But when we're talking about capital gains elimination, we're talking about 100% elimination. There's zero gray area, zero capital gains until the trust distributes. So let's talk about when the trust distributes. Pursuant to the trust has an automatic distribution provision that's in concert with the laws of perpetuity. And it says in the trust that the trust automatically distributes upon the death of the last sole surviving heir to the last sole surviving beneficiary. Now, many people get the wrong idea that they're talking about you, and that is not the case. Because this has been strategically designed to be a multi-generational trust, we're talking about the fact that you will invariably pass on. You'll have a successor trustee and successor beneficiaries, your kids, their kids, their kids, their kids' kids, and so on and so forth. The trust is meant to survive until there are no more survivors. This could be 100, 200, 300 years or more from now. But the fact is that everybody that was either directly or indirectly connected to your family tree will have gone to dust. And then upon that death, like I said, of the last sole surviving heir to the last sole surviving beneficiary, when those two people finally pass on, that starts a 21-year period where nothing happens. And at the end of the 21st year, the trust automatically distributes. Well, when it distributes, there's nobody alive that's either directly or remotely connected to the family tree. Therefore, any tax liability that might be due cannot be paid from anyone from the trust. And at that particular point, everything is concluded, and if there is any tax that's owed, the estate would then the remaining estate would then go back to the IRS for settlement and any other governmental bodies. And again, this is likely to be hundreds of years from now, so it's of no concern. And our trust truly simplifies the accounting process. I get asked this all the time. Bruce, is it more complicated to operate out of the trust? Actually, we chronically and consistently get told that from trust clients that it's easier and simpler to work out of the trust once you understand the rules of the road. And that's what we're here to do, is to educate you. So if it's good enough for the Kennedys, this is a reprint from 2014, where this article in Forbes magazine talks about how the billion-dollar Kennedy family fortune defies death and taxes. And this sentence really stuck out at me. In the article, Forbes says, capital gains taxes could potentially be deferred for forever. According to Forbes magazine, in a subsequent article, it references the fact that the Rockefeller family still maintains a substantial fortune, and much of it's intact because of the fact that they had trusts. We believe in full transparency. The trust never conceals or misrepresents. All income and expenses are shown and tied 100% to the following tax returns, whether it's a business income tax return or a trust income tax return or a personal income tax return, makes no difference. And in fact, none of the tax professionals we work with, having prepared countless thousands of returns over the years, have ever been audited. Heck, we have one tax preparer that works with us who's prepared over 8,000 returns and never had one audited over a 25-odd year period of time. Now, tax avoidance is legal, and I'm here to show you the difference between what tax avoidance is versus tax evasion, which of course is illegal. So according to the Department of Treasury IRS Handbook, Special Agents Handbook 412, tax avoidance is not a criminal offense. And it says in that booklet, any attempt to reduce, minimize, or alleviate taxes by legitimate means is permissible. Here's how the IRS works. There's a big misconception amongst taxpayers regarding how the IRS really works. Now, I can tell you, we even have enrolled agents who work with us doing tax returns. So we really know how the IRS works. Other than tax evasion, fraud, and failure to file income tax returns, and incorrect tax position taken in good faith is not criminal. A person would simply be assessed the tax that they would normally pay anyhow. There's nothing to lose, much to gain by establishing a platinum trust. U.S. Court of Federal Claims versus U.S. District Court. The U.S. Court of Federal Claims and the U.S. District Court are refund courts. Disputed tax liabilities must be paid first before cases are heard. There haven't been any cases found in either of those courts regarding our trust, plain and simple. Let's talk about the U.S. Tax Court. The U.S. Tax Court is where the majority of the tax cases are heard. Of the 175 cases on record involving estates and trusts from 1992 until now, there's been approximately 69 of those cases that involved trusts, and they all involve what's called a grantor trust. Well, our trust is a non-grantor, the polar and absolute opposite of a grantor trust. Legal case rulings. Well, the Edison case ruled that a person may adopt any lawful means for the lessening of the burden of income taxes. And in the Weeks versus Sibley case, the courts ruled that a spendthrift trust organization is not illegal, even if formed for the express purpose of reducing or deferring taxes. So let's talk about how some people have been very strategic and eliminated taxes. Heck, in the case of Jeff Bezos, he had an $11 million profit several years ago. And in that particular year, 2018, he even received a $160 million refund. But there's more. 60 of the largest companies, including Amazon, Netflix, and IBM, paid no taxes on the staggering pre-tax income of $79 billion. And there's more. What do these millionaires all have in common? Well, Joseph Kennedy established a dynasty trust back in 1936 that avoids state tax. Mitt Romney established an intentionally what's called defective grantor trust that avoids gift tax. Donald Trump established blind trust to hide his business assets. And this is an article that I saw last week. It was right on the news. Kamala Harris keeps assets in a tax advantage trust. Guys, I'm not here to pass judgment and say what is right, what is wrong, what is good, what is bad. I'm here just to broker information and tell you what the facts are. And the facts are the trusts work, and the trusts can do an unbelievably good job at mitigating tax if structured properly. The history of our trust. This type of tax mitigated trust was first copyrighted back in 1999. Today, there's over 65 copyrights on this type of trust. Over 40,000 of our trusts are currently in existence, designed by a collaboration of tax attorneys, CPAs, and other professionals. Took over 15 years to perfect this strategy. And the fact is, as is the case with the Jeff Bezoses of this world, they had great tax advice and great legal advice. And we have great people who have worked on to create our trust. Payment of taxes is deferred until sometime in the future when the trust assets are distributed. Well, you know when that is. We just discussed the terms of the distribution of the trust. And the trusts were written with two primary purposes in mind. First of all, asset protection and tax mitigation. We're in full compliance with all trust laws and conforms with all contract and trust and tax laws in all 50 states. So what makes our trust unique? It's the combination in the way that these various components interplay in a unique fashion. The dynasty, irrevocable, non-grantor, complex, discretionary, spendthrift, and non-self-settled provisions. The spendthrift provision I find very interesting. It's a critical element of the document in that the fact that there's no spendthrift trust corpus may be penetrated. The corpus is the center of the trust. It's where all the assets are kept, may be penetrated to reach the assets of the corpus. No judge or court may issue a turnover order against a properly constructed spendthrift trust, with one exception, fraudulent conveyance. Matter of fact, there's never been a properly constructed spendthrift trust that's been overturned. So let's talk about what fraudulent conveyance, an example of fraudulent conveyance. Well, an example would be you've been sued. You've gotten a summons and you know you've been sued. And then you go out and you try and create one of our types of trusts with the intention of trying to shield assets from the litigators, from the suit that you're involved in. That is a sheer and blatant case of fraudulent conveyance. And it's highly likely that if challenged, that the trust could be overturned. Now, if you're in that situation, let's talk anyhow. There could be things we can do, but I want to focus on what fraudulent conveyance is and the fact that it would not be a properly constructed trust if it was constructed with willful knowledge that there had been a suit that had already been instituted. This is just an exemplification of what a suit might look like. So let's talk about tax reduction strategies. Our copyrighted trusts are designed for the benefit of the beneficiary or multiple beneficiaries. Beneficiary expenses that are paid directly from a trust bank account to a third party are considered trust expenses. Money paid to the beneficiary or to a beneficiary or beneficiaries directly is a taxable distribution to the beneficiary or beneficiaries. So let me give you an example that'll really bring this optics into clear focus. Let's just say you have two children. They're both 18. You want to pay tuition for one and you want to buy the other one a car. There's two ways you could do it. One, you could give them the money, they put it in their checking accounts, and then one pays their college tuition to the Office of Admissions from their checking account. The other one buys the car directly from their checking account to the car dealer. And that is one way of doing it. And that's not the probable way you'd want to do it anyhow. And that would trigger a taxable distribution to the kids. So how do we create a trust expense? Simple. You would do what you would do likely anyhow, which is pay from your checking account, but this would be from your trust checking account directly to the Office of Admissions. Now you've got a viable trust expense. Likewise, let your son or your daughter go down to the car dealer, pick out their car, and then you just send over a check, make that out from the trust checking account, and now you have a trust expense, not a taxable distribution. Now, one of the things that you get when you get our trust is you get assigned to one of our tax professionals. And they are there for the balance of the calendar year to answer any and all questions that you have that are of a tax-related nature. They're also there and included with our trusts are the preparation for any returns that need to be done, meaning a basic 1040 and 1041. The 1041 is the trust return. So not only will you be able to get unlimited tax consulting, but you will also get your tax work done as a part and parcel to getting your trust. How do we do this? The ultimate tax deferral vehicle pursuant to Rule 643, which states the trustee is the sole and absolute authority to designate income as extraordinary dividends or taxable stock dividends. and that it is paid to the corpus of the trust, it's not subject to distribution. It is not income to the trust according to Rule 643. So what do we mean by this? Well, let's just say that you're selling some of your Bitcoin or your crypto. It's creating a that's would normally create a capital gain. And if you had the asset, i.e. the Bitcoin, for less than a year, it would be a short-term capital gain, in which case currently, federally, you're looking at roughly 30%. And if you had held it for a year and a day, currently, you're looking at roughly 20%. So if you have $1 million worth of capital gains, you're looking at writing a check for either $20,000 or $30,000 to the IRS. However, pursuant to this rule 643, actually A3, which we'll discuss in a moment, all capital gains are excluded when they go into the corpus of the trust. So you're going to sell and convey your assets to the trust. And this isn't just your crypto or your Bitcoin. This is also your cars. This is also your property, i.e. your personal property if you own a house, or properties if you're a real estate investor, your stock market accounts. But I want you to understand, when we talk about selling and conveying, we're not talking about you're liquidating your positions. We're talking about selling the ownership on paper to the trust, selling the ownership on paper to the trust. So what happens is the positions aren't closed out. We're just assigning and or selling the ownership to the trust. Now, if the trust decides to do any types of transactions, which, by the way, you'll invariably be the trustee of, so you have the total discretionary power to do or not do whatever you wish with that account. So if you decide to make a sale, then it's going to be the sale from the trust, and therefore the capital gains are excluded. Now that money is going to go right into that trust account, into your Coinbase or whatever other account. The money is going to go into your trust checking account. And you can be doing the types of transactions that we just talked about for your beneficiaries or for you. Matter of fact, you can, in the name of the trust, buy anything that you wish that's of a personal and or business nature, as long as it's not one of what we call the 3 F's. The 3 F's stand for personal food, personal fun, or personal fashion. So if it's not personal fun, food, or fashion, it's not going to create a taxable event. So what does this mean? Well, you can buy more crypto. You can buy a house, or you can buy multiple houses. You can do stock purchases. You can buy a jet ski. You can buy a mobile home, an RV. Again, anything and everything is something that can be purchased utilizing those capital gains money that's in the account, as long as it's not personal food, personal fun, or personal fashion. And if it is personal food, fun, or fashion, then it's going to be taxed. But likely, because your income, because you're utilizing our trust, is going to be dramatically lower on all of your passive income, any tax consequence for personal food, fun, or fashion is going to be dramatically lower. And we're going to show you in the next couple of minutes how you can be utilizing what we call the demand note for your personal food, fun, and fashion. And that's going to be another place to tap where you can use the demand note and not have any taxable consequences. Let's talk about some of the differences between what we call standard tax deductions and or tax, or I should say, trust expenses. Now, I like to go right down to, well, let's talk about room and board at college. We talked about that earlier. As you can see, it's not a standard tax deduction. And these are just a few examples. I talk about medical, heck, that goes right down to aspirin and cough medicine over the counter. But let's talk about home expenses. Let's say you own a house. Currently, the only tax deduction that you can take is the mortgage interest portion of the house payment that you make on a monthly basis. However, with the support and maintenance clause that's embedded in the trust document, now you have the opportunity for taking all home related expenses because the asset, i.e., the home, becomes an asset of the trust, which you control, just like Rockefeller. So let's talk about some of the trust expenses now that you take. Well, first of all, if you have a gardener, that would be a trust expense. If you have a domestic that comes in and cleans, if you have a pool person who does pool maintenance, uh, if you invariably you do have homeowners insurance, that is a trust expense. Also, all utilities, including your cable bill, is a trust expense. Any and all repairs and replacement of furnishings are trust expensible, and any remodeling that you might do, whether it's 100, 200,000 or more, would also fall into the trust expense category. So you can see that the depth and breadth of trust expenses is significantly wider and deeper than standard tax returns. I do want to talk about one other. We mentioned on the food, fund, and fashion that food, fund, and fashion is not expensible uh, off of the trust proceeds that when you have capital gains. Well, that's true, but there is a caveat. Let's just say that you've got children and the children are under the age of 21. 100% of their food, 100% of their fashions, and that can include Nike tennis shoes for 150 bucks. Those are all trust expensible items. So all food, all fashion for minors are trust expensible. How do I fund the trust? Well, you sell assets to the trust through a notarized bill of sale. It's a non-taxable event. Hard assets, equipment, computers, intellectual property, if you've got it. Many of you are business owners, so some of this applies. And some of you are not business owners, you're W-2 employees, but you have crypto and Bitcoin holdings. So that you do have, you will sell. That you don't, obviously, you're not going to. But likely you've got a car and or you have other items of value, furnishings, computers, so on and so forth. And again, if you have intellectual property, customer lists, these types of things, we sit down and work out what the calculations are very quickly and easily with you. And that goes to funding the trust. Bitcoin, crypto, rental and lease income from properties, business income that you may have if you own a business, it all goes into funding the trust. We'll show you, we work with you doing quit claims and warranty deeds for assets and properties and or properties to the trust. Once done, rental and lease income is now paid directly to the trust. So let's just say that you might be a real estate investor and you may have one or you may have 100 properties. Currently, the only relief that you get is the depreciation schedule for 27 and a half years. Well, I'm here to tell you that 100% of the rent and lease income that you pick up, because it's passive income, 100% of that becomes deferrable in perpetuity. This is a huge win for real estate investors. And for those of you who are Bitcoin and crypto investors and thinking about potential other diversification plays in the future when you might liquidate part of your portfolio, real estate is a great thing to get into. And you get great benefits being in real estate, having one of our proprietary and copyrighted trusts. Zero capital gains when Bitcoin, crypto, property, or maybe you're a business owner, you own a car wash, or you own a retail store, or whatever it is that you own, or you're a business consultant of types. That is something that when you decide to hang up your cleats and move on and you sell your business, of course, that would be normally generating capital gains, but you now know that capital gains is excluded from the trust. And you get to expense all payments related to any asset. So how do I get money out of the trust? Well, once the assets are sold to the trust, a demand note is created for reasonable valuation. Let's talk about a demand note example. Well, let's say you sell your assets to the trust and your total estate values at $1 million or $5 million or $50 million. It really makes no difference. You're going to then have a demand note for the value of the asset sold. And that demand note is either what's called book value, if they are personal property and or the business assets, and or at basis if it's real property. And again, we do this with and for you and get this all done. It's very easy to accomplish. The trust pays on an ongoing basis, on a discretionary basis, totally up to the trustee for support, maintenance, and managing trust assets as he or she so sees fit, including things like cars, estates, yachts, you name it. Paying expenses for beneficiaries, again, on a discretionary basis, such as education, medical, maintenance, and support. And you have access to the trust assets, including cars, properties, yachts, and more, RVs, you name it. Actually, a sidebar is the startup investment in the trust is also considered a trust expense and therefore goes into the demand note, where you can take out any amount from the demand note at any time for any reason and use that money as you so see fit from the principal, 100% tax-free. And this is where I'm saying you'll get back this sizable demand note and you can use it for anything and everything, including food, fun, and fashion, tax-free. There are no seizures on demand notes. As assets are sold to the trust, the basis or book value in the asset is added to the demand note of the person selling the asset to the trust. The demand note is not subject to seizures or claims by any court or jurisdiction. So this is kind of a recap slide on the tax mitigation piece. For assets sold to the trust, stocks, bonds, currency trading, of course, Bitcoin and cryptocurrencies, selling assets to another trust, real estate acquisitions if you have any, buying and selling of businesses if you have any. There's no federal or state probate with our trust and no gift tax. Zero capital gains on the growth or sale of trust-owned assets. The sale of assets to the trust are non-taxable events. And there's no cap. What do I mean by that? Whatever the size of the estate, and we have people with $100,000 estates, and we have people with $100 million plus estates that have our trust. And there's no cap on the amounts that can be sold to the trust. Now, capital gains are excluded pursuant to IRC Section 643A3. and I read, capital gains and or losses or exchanges of capital assets shall be excluded to the extent that capital gains are allocated to corpus. Well, because your assets will be trust assets, and when they're sold, the funds are going to go right back into corpus, this IRS tax code stays intact. And this is why we say, if you've done 1031 exchanges before as a real estate investor or heard about them, their 1031 exchanges are really obsolete when you have the opportunity to, instead of with a 1031 exchange, you're only kicking the tax can down the road from the previous property to the existing property until you sell that next property. Well, with ours, as you see, they are excluded. So let's switch gears. Let's talk asset protection and we'll do a wrap up. So your assets, including money and property, they can be seized currently. It's an unfortunate reality. Bitcoin is property, and property can be seized without a trust. Properties and assets cannot be seized. Property and assets held by a properly constructed trust cannot be seized. Further, the trustees and beneficiaries are not liable for any debts of the trust if there ever were any debts of the trust. So let's talk about corporations and LLCs. Now, many of you on the call today are business owners, and you may have a corporation or an LLC, and I'm directing this towards you. Some of you may be W-2 employees today, but in the future, you may want to start a business and become an entrepreneur. So you'll want to pay close attention as well to what we're discussing now. And the fact is, they don't protect you, plain and simple. It's easy to pierce the corporate veil. Alter ego is a third-year law student argument, and it's easy to prove with tightly held entities. Most entrepreneurs are solopreneurs or they're partnerpreneurs. They don't have 50, 100, 500 people. They're very small, therefore tightly held, therefore alter ego can be alleged and likely proven. And as this slide shows, one of the easiest ways to prove it is to prove alter ego by alleging insufficient corporate separateness. What do we mean by that? Well, let's just say that you are a puppeteer and there are these invisible strings going down to you, the entity, and therefore you are controlling you. And that's exactly what we're saying. You're very connected, and therefore there's not enough corporate separateness, and you're creating a facade, if you will. So how often does this work? Well, a study shows that it's at the state level, the corporate veil has been pierced when alleged 39+% of the time, and at the federal court level, 41% plus percent of the time. So having an LLC, a C or an S, and marching into court, you stand almost a 50-50 chance of getting the entity pierced. Not odds that I would want to be going into court with, trying to protect my assets. Now, reverse piercing is a newer kid that's on the block. Most of us have not heard about this, so you'll want to pay attention. It's when a lawsuit against you personally can allow the plaintiff to recover damages by reverse piercing the corporate veil, allowing them to reach the assets in your business entity as well as your personal assets. Closely held entities are at risk. So let's just say you get into a horrible traffic accident. And let's just say that you have an LLC with a business that you own. Yes, they could go after your LLC in your business that has nothing to do with the lawsuit to go and get reciprocity. I hate it, but it's the case. You could also face criminal charges for lack of parental care. There are some 30-odd states that have filial responsibilities, and they could go after your money to collect. This is a case here that we're talking about where this guy's mom got into a very bad car accident. She racked up a $93,000 bill with the hospital. She couldn't afford to pay it. And instead of the hospital writing it off as bad debt, they decided to invoke the Filial Responsibilities Act, went and found the son, and took $93,000 out of his account. He was enraged, to say the least. He fought the case all the way up to the state Supreme Court, where he invested more time and more money to plead his case, and he lost. So he really lost big. Here's my point. LLCs, heck, they cost $830 in the state of California. They don't protect you. C's and S's, same. Filial responsibilities and the potential of having somebody come after you, they're there. And with the trust, you can rest assured that they can't get at the trust, because you're only going to be keeping personally a matter of several $1,000s in your personal, what I call, account. So if you were ever deposed and needed to make what's called a declaration of assets, you declare your personal account, which is your food, fun, and fashion account, which, by the way, you can always move money over on a daily or weekly basis from your trust account. And that's all they're ever going to get. Statistically, according to IFG Services, you stand a 1 in 3 shot of getting sued as Joe Blow American, a 2 in 3 shot if you're a surgeon. 109,000 lawsuits filed every day, many of those against homeowners. Average business lawsuit, 72,500. Maybe that's because there's 91,000 PI lawyers out there. Certainly that's a contributing fact. And the number one lawsuit are slip and falls, where there are 25,000 of those occurrences on a daily basis. So this could happen at your house, condo, townhome. Now, in this case, this was a business owner that was sued by a contractor. The contractor was not doing work to code, so he didn't want to pay him. And I don't blame him, but he didn't have a trust. And ultimately, the contractor was awarded $150,000. Crazy, but true. Now, a lot of people say, well, I'm just going to insure up. And frankly, I would never suggest to you to cancel your insurance or your umbrella policy if you've got one. However, insurance will not cover these types of events. Actually, in this type of a situation, let's talk about the McDonald's hot coffee spill. Many of you are familiar with the McDonald's hot coffee spill, which was a $3 million award from the lady who is the lady who sued McDonald's for the hot coffee burns that she had. Well, I did a little deep digging on that case, and what we came to find out was that $2.7 million of the $3 million award was in punitive damages. And guess what? Insurance policies do not cover, even umbrellas do not cover punitive damages. And punitive damages, unfortunately, could wipe you out if you don't have a trust. Again, if you have the trust, the only thing they're getting is the chump change that's in your personal account. With the titanium vault asset protection, you're subject to, you are not subject to tax liens and levies issued against beneficiaries or trustees, divorce, alimony, child support, creditors, governmental agencies, or third-party claims, and not subject to court's jurisdiction for turnover orders unless fraudulent conveyance can be proved. We've already discussed fraudulent conveyance, so we're going to move on. A trust is not a person, which is why Cs, Ss, and LLCs are recognized as the equivalent of a person in all states, and therefore they can be sued. Conversely, our trust is a contract, therefore it is not recognized as a person, and therefore it can't be sued. It's going to get thrown out of court. Now, could they severably sue you? Yes, but we've already discussed what they're going to get out of you. It's going to be some chump change for a couple $1,000s at best. And the case has to get thrown out of court unless they can prove fraudulent conveyance. Let's talk about Matt. Matt's son got into a very bad traffic accident. He was 17 years old, so the responsibility fell on Matt. Matt was in the process of getting harassing phone calls from a potential litigating attorney and talking well in excess of $1 million going after Matt. Matt knew what to do. Matt called up the litigating attorney and informed him about the Platinum Trust. And what do you know? Matt never heard from the attorney again. This is not atypical. The attorney turned his attention to the underlying insurance policy that Matt had, and that's where they got partial reciprocity. And Matt did not get sucked into the equation, have to go in for depositions, and worry about what the potential outcome could have been. I have a friend, he got into a very bad accident as well. He did have an umbrella policy. His umbrella policy was over $1 million. However, as I told you earlier, umbrellas don't cover punitive damages. And above the umbrella policy, he had to pay out of his back pocket $250,000. Ask yourself, could I afford to pay $250,000 and have it not affect me? The answer is a loaded question. Likely not. So I like to pose the question to each and every one of you that's been with us for the webinar today. What would your future look like if you were able to control what you earned? I know that the answer for me and many, many others that we have touched and worked with that are clients has been a win-win scenario. On that basis, let me take you through what the trust package includes. First of all, you get a trust binder with all your custom documentation, soft copies with all the forms for your admin, which we go through, show you exactly how to use. They're very simple, and there's not that many of them. Unlimited trust tax advice until the end of the calendar year, like I said. Trust return preparation for both your basic 1040 and 1041, which is the trust return. Trust specialist / strategist assigned to you for your implementation. So we get you up, we get you running, and get you flying right. Ongoing access to the trust documentation library. Ongoing access to the trust Q&A calls and podcasts. We have a whole back end password protected group of podcasts. We have Q&A calls 2 times a week, which you're invited to. If you can't make it, no sweat. They're downloadable, so you can listen to them when you're jogging, whatever, by podcast. You have the ability to join those calls, and they are interactive with clients. And I got to tell you, you may have heard about business masterminds before, and business masterminds to join a group of others that are successful people like yourself. They can cost, matter of fact, they usually cost a minimum of $10,000, as much as $25,000 or $30,000 annually. Well, here's an opportunity for you to get with other people. There are other people that are crypto and Bitcoin investors that are part of this group, guaranteed. There are people that are successful real estate investors, some of which have over 100 properties, business owners from every walk of life, including lawyers and CPAs and other professionals as well. And you get the opportunity to be networking and hearing them, and invariably getting an answer to a question that you would have never thought of that they posed that could be transformational for you. So I cannot stress enough the importance of the Q&A calls and that opportunity that's there for you as one of our trusted trust clients. So if you want to get a complimentary consultation, all you need to do is scroll down to book your complimentary consultation, lock in your, that's correct, $10,000 discount right now. We accept Bitcoin, we accept Ethereum in addition to USD. If you are having a problem booking your appointment to get a strategy call, no problem. You can call to the below listed number, the 702-371-2345. Let me repeat that, 702-371-2345. The best thing to do is to get on the calendar where we're going to be able to sit and answer any questions that you've got on the trust and how it can work with you and your particular situation. I want to thank you so much for taking the time to be with me, learn about the Platinum Trust, and I look forward to working with you in the future. Again, thanks so much. It's been a sincere pleasure.